Now, this presentation is basically an overview of the main provisions of the U.S. Constitution. Some people may know all of this or some of it, but I hope you find it useful. I think it's a useful review if you haven't gone over this for some period of time. So it's based on you already having heard what I had to say in the previous video about who the framers were, what their political orientations and values were, and so now we're going to go into the actual terms of what they came up with. So now that's the background. That's who they were. A lot has been written about them. Charles Beard's book, An Economic Interpretation of the U.S. Constitution, goes into it in great detail. But now I'm going to begin going through the actual text of the Constitution. Now you need to know this, because this is our operating document today. I just want you to look at it with an understanding of where all these terms came from. Where these provisions came from, that they weren't given to us by the supreme being of the universe. They were written by people who were involved in enslaving human beings. I'm not saying that as a interpretive or judgmental comment. I am simply stating a fact. That is what a large part of them did. That is a fact, and needs to be taken into account when you look at the terms of the Constitution, as all these historical facts do. So we'll go through an overview, and then we'll talk about the powers of the national government. Then we will go, and this is more in the second half of this, limitations on state powers and federalism, the doctrine of federalism, separation of powers between the branches of the government, and how the Constitution is amended. So, number one, overview. Major doctrines that are in the Constitution and that were being talked about in political literature at the time include separation of powers, the idea that a government should be broken up into basically separate departments, branches, judicial branch, executive branch, legislative branch. This is an idea that was embodied in the Constitution. Separate power, don't unify power, but separate it. And then further divide it according to something called federalism. That is, not just splitting power between executive, legislative, and judicial, but also dividing it up between the national government and the states. Now, federalism is a critical part of the structure of the Constitution. And, most countries don't have federalism, but we do. The federal government is a government of enumerated powers, meaning the federal government can only do something if there are words in the Constitution that say that it can do those things. Whereas the state governments can do anything that is in their own constitutions, their own powers, as long as it isn't prohibited to them specifically by the Constitution. We call it reserved powers. So state governments in this country don't need to look to the U.S. Constitution to find their powers. They look at their own state constitutions. The federal government, however, has to find its powers in the Constitution or it can't do it. Every single piece of legislation that Congress passes has to be authorized by a part of the Constitution. Another important part of the deal in federalism was to preserve slavery. And they did this to secure ratification by the southern states. The southern states were not going to ratify the Constitution and join the Union unless slavery was preserved. And we know that because when slavery was threatened by the election of Abraham Lincoln in the election of 1860, southern states seceded from the Union. So we know that they would not have joined the Union in the first place. This was a deal that was made. It's a compromise that was made between North and South to bring in the southern states. Otherwise, they would have gone their way and been a separate country, apparently. Another important provision is the amendment process. Now, it is very hard to amend the U.S. Constitution, but it is there. I mentioned already the ratification section of the Constitution violated the rules that were already laid down in the Articles of Confederation. And another important thing is civil liberties and civil rights, which were added. They're not in the original Constitution. They're added afterward into something called the Bill of Rights, the first 10 amendments of the Constitution. Those were done afterward, and they were added. They were promised in order to secure ratification, and that's why they had to do that in the first Congress. So basically, there's a picture kind of how things look. You have a U.S. government with certain defined powers and relationships among the three branches. We call it separation of powers. Some people call it checks and balances. And then we have state governments and the doctrines of federalism. And then we have, quote, the people, the individuals, who get certain civil liberties and rights, which are explained in the text of the Constitution. And now this is something I want to emphasize. You know, this diagram shows another arrow going left and right between state governments and the people. Point being here, the Bill of Rights originally did not limit state governments. Very important thing for you to understand. The Bill of Rights only limited the national government, and it was put there because of part of a promise that was made during ratification debates. No, if you ratify this, we promise we'll give you a Bill of Rights to protect you from this new national government. It was originally not intended to limit states at all. The 14th Amendment in the Civil War changed that. The 14th Amendment Due Process Clause gradually came to be interpreted to apply most of the Bill of Rights to the states as well. This is called selective incorporation. We will talk more about this. We're going to cover civil rights. But understand, now the Bill of Rights does protect us against the actions of state governments. But originally, it only protected us against the national government in Washington. Now, I'm not going to go through this in all sorts of detail. You've heard a lot about this, the various plans, compromises for how to structure the government. You know, the Virginia plan, there were different ideas. Representation should be based on population. The small states saying, wait a minute, states should get equal representation. And we end up with basically a compromise. House in the national legislature that is based on population, that's the House of Representatives. All districts have about the same number of people. And then we have the Senate, where all the states are equal. So a state like California, which has, 35 million people or something, has the same number of senators, 2, as the smallest states in the U.S. that have 2 senators, like Rhode Island and Wyoming, the ones with the tiniest population, Alaska, Montana, less than 1 million people, etc., as in numerous states. And here's California with 35 million, 2 senators. Here's the tiny little states, 2 senators each. So that's a compromise that was struck. The compromises on the treatment of the enslaved population are a source of great shame for the United States. And this is in the original Constitution. Now, these provisions were eventually essentially obliterated from the Constitution. They're still there, but they were invalidated by the 13th Amendment to the Constitution, passed after the Civil War, which abolished slavery completely and made it illegal. But the original Constitution, before the 13th Amendment, perpetuated the institution of slavery. It put the slave trade out of limit for beyond regulation for 20 years. It created something called the 3/5 Compromise, which addressed the problem of how to allocate members of the House of Representatives to the states if some of the states had enslaved people and others did not. In other words, how should the enslaved population be counted in determining the population of a state? Now, if you're Virginia, you're saying, we should definitely count the slave population as individuals, because that would give them more members of the House of Representatives, and they'd have then more power to protect slavery. But northern states' representatives at the Constitutional Convention were saying, no, you cannot count the enslaved population because they don't have any rights, and you say they're property, and now you want to count them. It's not fair. They shouldn't count. So they reached a compromise. They said you can count 60% of the slave population toward the number of representatives you get. So that gave the South some credit for the population, the enslaved population, but not 100%. So that's called the 3/5 Compromise. Again, these are now things that are sources of great shame for the United States of America and its history. And these are things that some people wish we didn't talk about. There are some people who like to criticize what they call critical race theory, and they don't want us to talk about these things. And there are laws being passed in some parts of the country to prevent K through 12 teachers from even talking about it. But we're going to talk about it. And so if anyone doesn't like it, they can take it up with someone. But this is a fact. These are the things that the United States did, and they are part of the original Constitution to its enduring shame. So now let's quickly go over the structure of the Constitution. You don't have to memorize this, but I want you to understand it. There is a number of articles. Article 1 is long and detailed, and it is the article that describes the legislative branch or the legislative power. This is important because understand the way the founders intended the Constitution to work. They thought that Congress would be the first and most important branch of government, not the president. Understand? This is very clear from reading the Federalist Papers. The founders thought this country was going to be run by Congress that would give the president things to do, and the president would do what Congress told the president to do. That is not the system we currently have. We have more of a system of presidential supremacy. But the original plan was legislative supremacy. They gave all the powers of the national government to Congress. I underlined that Article 1, Section 8 enumerates the powers of the national government. Well, they're described as the powers of Congress. And so that's an interesting thing. Article 2, relatively short, describes the executive branch, which has greatly expanded, as you will learn. There's no mention here in Article 2 of the federal bureaucracy, which is in the executive branch. It was created later and put in the executive branch by Congress, but it's kind of interesting because it isn't even mentioned in the Constitution except for a few basic departments. Article 3 is the judicial branch, the federal courts. We'll have a lot to say about that. Article 4 talks about federalism, the federal relationship. The states have to respect each other's legal decisions. Citizens have to be treated equally when they go between states, and so forth. Article 5 is the process for amending the Constitution. Article 6 has a number of things in it. Section 1 is very important. It says that the federal government is responsible for the debts incurred under the Articles of Confederation. Remember paying off those bondholders? Yeah. Section 2 of Article 6 talks about the supremacy of federal law, the all-important Supremacy Clause. And Article 7 describes the ratification process. So what I've done here now I'm going to go through this you need to read this. You'll need to read this on your own, but I'm going to go through and highlight. These are the key terms. What I have highlighted here in the text, the 4,000 words of the plus of the Constitution, I've highlighted the key terms. So first, on the powers of the national government has only enumerated powers. These are things you'll probably be testing you on, meaning that the federal government has to find its powers in the text of the Constitution or by implication from the text of the Constitution. But the states have reserved powers. They don't need to find their authority to act in the text of the U.S. Constitution, and that is explained in the 10th Amendment. The 10th Amendment says the power is not delegated to the U.S. by the Constitution, nor prohibited by it to the states, are reserved to the states. In other words, like I said, federal government has to find its powers in the text of the Constitution, but all the other legitimate governing power is reserved to the states, unless it says in the Constitution you can't do this. And there are things in there that the Constitution does say states cannot do. We call it the police powers. The things the reserved powers of the states are called the police powers. It doesn't mean police officers. It means protecting the health, safety, and welfare of the people. That's what the states are supposed to be doing. Protecting the health, safety, and welfare of the people. The core of the Constitution, in terms of laying out the powers of the national government, is Article 1, Section 8, the powers of Congress. Congress shall have power. And then it lays out collecting taxes, etc., paying the debts, defending the country. See, these are the powers of Congress. But we think of them now, more often than not, as the powers of the president. Borrowing money, regulating commerce. This is one of the most important powers that Congress has, the power to regulate commerce with foreign nations and among the states. That's called interstate commerce. Naturalization, money, post offices, etc. And that, look at the bottom, to constitute tribunals inferior to the Supreme Court. Congress has the power to create federal courts, which they did immediately. And on and on. I won't read all of them, but you can see these are the main powers of government. Declaring war, raising armies and navies. And very important, look at the very bottom, to make all laws which shall be necessary and proper for carrying into execution the foregoing powers. So Congress doesn't just have the powers that are listed. They also have implied powers from the necessary and proper clause. They can do anything that is necessary and proper to execute the powers that we've just read. Now, this is the Commerce Clause. Gives Congress the power to make one set of rules for everyone who participates in the U.S. economy. This is a very important clause. Here's the Taxing and Spending Clause. Congress can lay and collect taxes, pay the debts of the United States, take care of its defense. The Necessary and Proper Clause, again, was sometimes called the Elastic Clause, the one we just covered. The preservation of slavery that I mentioned as part of the original Constitution included several different things. And these are the provisions that are most important. The first was Article 1, Section 2, Clause 3, which is called the 3/5 Compromise. And the idea here was that the South wanted to give no rights of personhood at all to the people they classified as slaves, or we would call enslaved persons today. They wanted them to have no rights. However, the South did want them to count for purposes of allocating representatives in the House of Representatives. So they wanted to have it both ways. They wanted to be able to count the enslaved portion of their population, which in states like South Carolina was actually probably the majority of the population. So they would have more power in Congress, and that would allow them to preserve slavery. And most of the northern representatives said, well, you should not be able to count the enslaved people at all because they have no rights, and therefore you can't give them no rights and then say that they are now people or citizens for purposes of giving you more representation in Congress. And so they compromised. The compromise was that the total number of enslaved people in a state would not be counted, not the total, but 60% or 3/5 of them would be counted. So it was just a numerical compromise. Second, Article 1, Section 9, which basically says that the slave trade is protected in the United States until the year 1808, so that it says it cannot be prohibited. That is, the importation of captured people, kidnapped people from Africa, cannot be prohibited by Congress before 1808. And then Article 4, Section 2, which says that, in essence, that if someone who is enslaved in one state escapes into another state that does not have slavery, that the authorities in that state are required to turn the person back to the party who claims to own him. This is one of the most objectionable parts about the entire Constitution. The idea that people are forced to return people who had escaped slavery to the enslaved, to the slave owning people in the southern states. So that is how slavery was preserved. This compromise was thought to be necessary, apparently, by the northern representatives in order to keep the South in the Union. And of course, this raises the question of whether they should have kept the South in the Union. But this is what, in fact, the compromise
We're going to talk about the limitations on state powers and the very important doctrine of federalism. We will then talk briefly about separation of powers, and I say briefly because we're going to have an entire week on the presidency, a whole week on bureaucracy, a week on Congress, a week on the courts. So I won't go into the details there, but I am going to talk about what separation of powers is and some of the basics. And then we'll talk about the amendment process. So first, federalism and the Constitution's limits on the powers of the states. You remember that under the Articles of Confederation, the state legislatures were very powerful and there was a weak national government. So, the Articles was a system of strong states and a weak national government. And that is one of the main things that the people who wrote the Constitution intended to change. They wanted a stronger national government, but they wanted to keep the states still with a certain amount of sovereign power. In other words, they were still going to be functional governments. They were going to have an important role, but they weren't going to be as powerful as they were. So the Constitution limits the functions of states in a number of very specific ways and sets out a whole new relationship between the national government and the states. And we call this a system that has two levels of government. We call that federalism. And we'll talk more about that. Let's go into it. A federal form of government, like what we have, is one in which the governing power, the power to govern the country, is actually shared between a national or central government and some kind of territorial subdivisions. They could be states or they could be provinces, but some kind of territorial subdivisions. And these power relationships really have to be described in a constitution. They could be, and if they're not, it's very complicated to try to administer a system of federalism, because you really need written constitutional provisions that you can read and interpret, or else you can have all kinds of conflict over what the national government can and can't do and what the state or provincial governments can and can't do. Now understand that in almost all federal nations, including ours, the subdivisions came first. In other words, in this country, the states came first. We had states before we had a national government. And that means the states do not derive their right to exist from the national government or the U.S. Constitution. They pre-existed the Constitution. We had states before we had a Constitution. We had states before we had a national government. And both the national and the subdivisional governments, in our case the state governments, have direct links, direct connections to the people. Now, as opposed to what? Well, there's two alternatives. One would be a unitary government, where all the power emanates from the central or national government, and the subdivisions are basically just subunits. They're just administrative subunits of a central government. They are not autonomous governments that have their own power and their own connections to the people. That would be what's called a unitary government. And that is a very common way to run a country. France, China, many big nations around the world are unitary governments where all the main power emanates from the national capital. And the subdivisions are there to administer national policies. In many cases, the subdivisions were actually created by, or they exist at the pleasure of the national government. That's not the system we have, clearly, but many countries have that. And the other end of the spectrum is a confederation. That is an extreme form of federalism in which almost all the power is in the hands of the territorial subdivisions. Now that would be the U.S. under the Articles of Confederation, or the Confederacy, the Confederate States of America during the Civil War, or the United Nations. A confederation is basically a union of sovereign nation states, in essence. Now, so we started off on this continuum way over on the left as a confederation, and then we moved more with the Constitution and other events more toward being a federal system, which is what we are. But we have never moved toward being a unitary state where the national government has all the power, like China, France, Italy. So we're not like that. Now, what is good or bad about federalism? Well, here's the good part. It is good for multicultural nations. It is good for nations that have a lot of different parts of the country, regions, areas that have different kinds of populations. Maybe people speak different languages. They are predominantly from different racial groups, religions, etc. And so if you have a multicultural nation, you can kind of avoid civil war and endless conflict by letting the states or the provinces kind of do their own thing in a number of policy areas and do what the people in their state want them to do. So you don't have one rule for the whole country in certain policy areas. It also lets you preserve local identity, linguistic identity, for example, religious identities, that sort of thing. And another advantage is that it allows the citizens multiple points of access to the political system. We have that. We have, if you don't get what you want from the national government, well, maybe you can get it from your state government. In theory, some political scientists say it offers a protection against authoritarian government because you have so many different governments. It's very hard for a national government to control everyone. That's debatable, but some say that. On the other hand, federalism is very cumbersome, particularly if you have a nation with homogeneous populations. It is complicated. Endless reconfiguration and discussion and amendment and lawsuits and tinkering, and sometimes very slow decision making because you make a change in national policy and then you have to make it in a whole bunch of different states. And then there can be a lot of disputes. And we have had a lot of disputes over whether we would have one uniform rule across the country or a lot of different rules. Even things like, policy regarding the COVID pandemic. And obviously, the number one failure of our system of federalism was the Civil War that resulted from the conflict over slavery, where, the southern states would not accept the abolition of slavery, which had not happened yet. But even when they thought it might happen, they seceded from the Union and there was a civil war. How common is federalism? Well, we have about 193 nations, maybe a few more, in the world. Only about 25 of them have systems of federalism. However, it's 40% of the world's population. And if you look at them, they include some of the most important, powerful, and populated nations in the world, and some of the best and strongest economic systems, such as Argentina, Australia, Austria, Belgium, Brazil, Canada, Germany, India, obviously an enormous nation, Mexico, and on, and the USA. Unitary systems, as I said, China, France, Japan, Italy, the UK, Cuba. Obviously, China's an enormous country with a unitary system. So it's a minority of the nations and less than 50% of the population, but a lot. Now, to understand federalism, first you've got to get clear on the Supremacy Clause. Article 6, Paragraph 2. This Constitution and the laws of the U.S. shall be the supreme law of the land, and the judges in every state shall be bound thereby. So, national law is supreme if it is in compliance with the Constitution. Now, if it's declared unconstitutional, of course, that's a different story. Then it's invalidated. But laws made that are constitutional by Congress are the supreme law of the land. And state laws that are in conflict with a legitimate federal law are invalidated. So that's one important provision that limits the powers of states. Then I mentioned a number of other things, but that we can get to in a minute. But let's jump. Stay with Article 10. Article 1, Section 10. This is where the states were put out of certain type of governing business that they were doing. No state can enter into any treaty or confederation. You see, the states prior to the Constitution were engaging in their own foreign policy, and they were trying to make treaties. So you'd have a treaty of South Carolina with France, and then Virginia might make a treaty with the UK, this sort of thing. Well, that has to stop. Section 10 says no, they can't do that anymore. They also cannot do other things. They cannot, you can read them, but note that they cannot impair the obligation of contracts. This goes back to that notion of the elites again. States were passing laws that were invalidating certain types of contracts. And so in people who were, let's say, owed money, like a banker, would suddenly discover they weren't going to get that money because the state legislature passed a law saying people didn't have to pay them back because of the nature of the contract that they wrote. Maybe the interest rate was too high. And the state said, well, if the interest rate is above 8%, you're not going to get paid back. In other words, they were impairing the obligations or blocking the enforcement of contracts that had already been entered into. Well, that's all. The states can't do that anymore. Contracts are supreme. And you can see on and on. They can't tax imports and exports and so forth. engage in war, blah, blah, and so forth. So states are put out of certain type of business they've been engaging in. Now we have another series of provisions here. The full faith and credit clause. This we're going to go through, more of this in a bit more detail, but essentially, the idea here is that the full faith and credit clause requires that the states recognize the laws and the judicial findings that happen in other states. The reason they had to do this is because some states were saying, well, we don't care what law they passed in Virginia. We're the state of Pennsylvania. We don't have to acknowledge what they do in that state. Well, yes, they actually do. Now, why has this become important? Well, imagine like today, if you had a driver's license and issued by Illinois, and you drove into Indiana, and they said, oh, no, you can't drive in Indiana. You don't have an Indiana driver's license. Or let's say you own a piece of property here in the state of Illinois, and it's yours, you have the deed, and the state of Indiana refuses to acknowledge that you own that property, and instead they say, well, we don't recognize Illinois deeds, we're going to give that property to someone else. See, this wouldn't work, would it? Or you get married in one state, and they say in another state you're not married. Or you get divorced, and they say in another state, we don't like divorce, so you can't be divorced. So it would cause all kinds of problems. Now, I said that they awarded the national government this special status, the supremacy clause. However, the 10th Amendment is still there, and in the 10th Amendment, which we went over, protects the states to a substantial extent. In other words, it says that, remember, the federal government has only the powers that it is given, and the states have all the other powers they call the reserve powers, the police power. So what that means is, despite the fact that federal law is supreme, it's only the laws that are actually written in the Constitution, the laws that are passed legitimately by Congress pursuant to a specific authorization in the Constitution. In everything else, the states remain, as we say, first in time and first in right. So the Constitution says the federal government is supreme in its own defined realm, but outside that, the states are still the sovereign power. Some very important cases. And there are many other areas where right now there are debates over the power of the national government with respect to the states. The rights of the LGBTQ population, abortion and other reproductive right decisions, the death penalty, immigration, healthcare, COVID, the Affordable Care Act. All these things implicate the powers of the state and the national government, and then many things about religion. So we'll always see this dynamic where if one party controls the national government, states that are controlled by the other party will try to go in a different direction and push back against federal policy at the state level. That's an enduring dynamic of our system. So now that's federalism. Let's turn briefly to separation of powers. We're going to have a whole chapter on all the branches of government, so I'm not going to spend a lot of time on this right now except to understand the basic idea. The theory is power has to counteract power. The idea was, when they wrote the Constitution, don't let despotism come into existence. Don't have an overly powerful executive, an overly powerful legislature, or overly powerful courts. Each branch of the government has to have ways of frustrating, blocking the other branches. And why? So that they have to cooperate with each other. So that you can't have tyranny. That's the theory. And I'm not sure this is necessarily always going to work, but that's the theory. Okay? Ambition should counteract ambition. And so here's an example of it. In the case of legislation, well, first, it requires both houses of Congress, the House and the Senate, to pass a bill. But then the bill has to be signed by the president or it doesn't become law. The president can veto it. Then it goes back to the Congress and they can override the veto. And then you have the courts that can declare laws unconstitutional. And you see, you get the idea. The executive branch tries to staff itself by the president making appointments. They have to be confirmed by the Senate. The president makes a treaty, has to be ratified by the Senate. You get the idea? So all these things are checks and balances where no branch can become too powerful. Now, in the House of Representatives and the Senate, in the legislature, we use the terms bicameralism and presentment. Bicameralism means two houses. That legislature must pass both houses by majority vote in exactly the same words. That's called bicameralism. Presentment has to be presented to the president. Veto is when the president says, I veto this, and sends it back. Override is where 2/3 of both houses overrule the president and pass the bill over the president's objection. What's the result of all this? It's hard to pass legislation. That's the idea. Frustrate tyranny. The federal judicial branch, well, they are given lifetime appointments that insulates them from the election process. They don't have to run for office, and they can't be gotten rid of except by impeachment, which is very, very hard to do. So neither branch can really do much about them. Now, federal judicial power is limited. We'll talk a whole week about that. They only do certain things. But they do have, the federal courts and in most state courts, do have the ability to void legislation that if they believe that it violates the Constitution. We call that judicial review. And this is a source of great controversy when the Supreme Court particularly, but any federal court could potentially do this. But to the Supreme Court, it really generates a lot of objections when they do it. And then let's talk about the amendment process. Okay, the Bill of Rights is actually a series of amendments. It is the first 10 amendments to the Constitution added in 1791 all at once. But since then, since those first 10 which were done all at once, the Constitution has been amended only 17 additional times in all those years. So we have 27 amendments. Why so few? Oh, it's very hard to do. Now, it is possible that there could even be a constitutional convention, and we could have a new constitution. That can actually happen, and it's worth asking what that would look like. But here's the way that amendments can be proposed. They can come from Congress if 2/3 of both houses vote to do it, or they can come from a national constitutional convention. We haven't had one of those since 1787, but I'm just saying we could, right? And how do they get ratified? So normally our amendments are proposed by Congress. That's how we get them. And they either get ratified by 3/4 of all state legislatures or special state conventions, which we don't really do. The way it's always set up now, these days, is Congress drafts amendments. They pass by 2/3 of both houses, and then they have to be ratified by 3/4 of all state legislatures. Okay, that's really hard to do. Very hard to do. I just call to your attention, there are other methods, particularly, just understand. It's possible that we could have another constitutional convention, and then that's the approach down below, a national convention. It could happen. It hasn't happened since 1787, but remember what they did last time? They took their existing constitution, which was the Articles of Confederation, and threw it in the garbage and started over. So anything's possible if you have a constitutional convention. Now, I want to go through the amendments and then we'll be done. We're going to cover civil rights and civil liberties at some length, but this is what you need to know now. Amendments 1 through 8 deal with individual rights and liberties. Amendment 9 says there may be other rights and liberties that we haven't written down yet. This is a very interesting amendment. Think about that. They're saying just because you don't have in writing a given amendment in the first 8 doesn't mean there aren't others. Isn't that interesting? And number 10, amendment number 10, the 10th Amendment, says the states have the reserved powers. We've talked about that. Now, several amendments basically expand the electorate. The 14th, as we've talked about, 15th, the 19th, 23rd, 24th, those are all about expanding the electorate. Then we have other amendments that change the relationship between the elected officials and the electorate in various ways, mainly about the presidency. There are a number of issues in here about the presidency. And then there are the ones that limit the powers of government, 11, 13, 14, 16, etc. So, what I'm getting at here is that these amendments really didn't go into the heart of the Constitution and change it fundamentally. Understand that is possible. Anything can happen with a constitutional amendment.